Just over 400 years ago, in February 1619, the man the English would come to know as James I gave judgment in the Star Chamber. It was the last time he would do so, not the last time he thought about doing so, but the last time he would do so, and the final occasion on which a monarch of England or Scotland, or as he would have preferred Great Britain, would publicly sit in judgment on his subjects. Now, James's attempts to interfere in the work of his own judges have been a staple of constitutional history, and they've been discussed in some detail. But James's actual judicial activity has been more or less ignored. It's occasionally noted in passing. Conveniently for this conference, James VI and I was just that. He was James VI of Scotland and James I of England. He wanted to be King of Britain, but his subjects disagreed, and the two realms remained rather distinct. James was, therefore, a regal transplant, and that enables some comparison between two distinct places. And while comparative law and comparative legal history often focuses on transplants of legal rules, movements of personnel can also, of course, be very important. At least for now, law can only be applied by people. And as people move, the law in practice can change. For James, there is another comparison we can undertake, and it's the comparison between theory and practice. James, as people will know, was not reticent about presenting his thoughts about kingship, or much else, and his writings and speeches let us build an understanding of his views on the role of the king as judge. And while he didn't judge often, he did do so, which means we can compare what he says about what a king should do with what a king actually did, which is a pretty unique situation. And in this paper, I want to argue that James saw judging as an important part of kingship in general, and crucially of his kingship. He also identified giving judgment as one of the methods by which he could not only be a king, but actually run the country. Royal judgment was a part of royal government. And along the way, we have essentially the subject matter of an episode of Game of Thrones. We have witchcraft, dueling, poisoning, and incest. Now, before considering the cases in which James does judge, there is this really awful question about what does it actually mean to be a judge, which I'm largely skating over in this paper, but it's quite an important issue. We have the first obvious problem that there are an awful lot of things in England and Scotland circa 1600 which are technically done by James, but which he doesn't actually, of course, do. It's just his name is put on the document by somebody else. I am ignoring all of those, unless there is any evidence that James himself was personally involved in the decision-making, which is rare. Similarly, I'm ignoring various aspects of informal resolution of disputes. James is certainly involved in that in both of his kingdoms and quite probably actually some Irish matters as well. That's the case even when the dispute may have reached a judicial stage but ends informally. So there is, for example, one of David Black's appearances before the Scottish Privy Council for unwelcome preaching. At the start of the proceedings, David Black declined the king's judicatory. So this is clearly a judicial matter at the start. He's saying the king doesn't have the power to judge this. The case ends, however, with King James and David Black in private and homely conference. So it ends in total anticlimax. The other thing I'm not going to talk about are interventions by James in judicial process to either expedite or delay proceedings, which is actually what constitutional historians have mainly talked about. Those are clearly important. There are far more of them than we've actually realised, I think. But in those cases, there's no evidence of him determining the outcome of the disputes, so I've put them to one side. That means that what I am talking about are really the best evidenced examples of James's judicial activity, but also probably the ones that are all in some sense exceptional. Sorry. But there is some evidence in Scotland of James's participation in the regular administration of justice, that he is regularly involved in dispensing judgment. There are references to him attending criminal courts in 1589, 1590, and in 1598 a court hearing is delayed to enable James to attend and dispense judgment, although there's no subsequent evidence that he in fact did so, so quite what happened with that case isn't clear. Not always clear if he's only attending in those cases. He certainly did attend the Court of Session, but there's not evidence from those instances that he was judging in the Court of Session. In fact, he probably wasn't, but he's sitting in court with the judges. By 1601, however, in relation to criminal matters, James is giving judgment, at least to the extent of giving sentence. In that year, an English agent wrote to London saying that James VI is become a great justicer, having executed a Douglas, a Maxwell, a Johnston, and 2 other gentlemen for stealing and coining. So James here is passing sentence on 5 individuals for 2 different offences. We haven't been able to find further details of those particular cases. It's not entirely clear where those cases took place, which makes finding them tricky if it was outside Edinburgh, and not that easy if it was in Edinburgh. James also attended the Scottish Privy Council, which is a body which undertook a wide range of judicial activity. He is recorded, possibly inaccurately, as having been present when cases were resolved, in cases determining interlocutory matters, and in terms of cases involving jurisdictional questions. For most of those cases, though, we have no evidence of his personal participation in the proceedings. We don't know what James did in those cases. But in his Basilican Doran, which he writes ostensibly as an advice manual for his eldest son, Prince Henry, while in Scotland, so this is very much on the Scottish side, James gives advice about sitting judicially in the Privy Council, suggesting that he did in fact participate in the proceedings. He tells his son what he should be doing. And Scotland, in fact, had a tradition of direct royal involvement in the administration of justice, particularly criminal justice. All of James's 16th century predecessors were involved in travelling with the justice heirs that went around parts of Scotland, as were James's regents before he reached the age of majority, with one exception who wasn't regent long enough to do so. And that activity in Scotland is seen as something that a good king should do. They should be involved in the regular dispensation of criminal justice. The English situation there is quite different. There's no evidence of James's direct judicial involvement in the regular dispensation of justice, civil or criminal, merely a handful of unusual cases. And it's to those unusual cases, English and indeed first Scottish, that I will turn now for the rest of the paper. The first group are in the Scottish Privy Council. Privy Council's jurisdiction was wide. James's personal involvement is clearly identified in cases about seditious or treasonous speech, in particular seditious sermons. The first example is actually from December 1585, so James is only 18 at the time. James Gibson is brought before the council, and Gibson himself identifies the 18-year-old James as a judge. Gibson is required to take the council through his sermons step by step, every step in the theological reasoning. James personally comments at each stage on the acceptability of each step of the scriptural exegesis, and James accepts all of the reasoning until the very final step in the sermon. Gibson concluded that a king maintaining wicked acts against God should be rooted out. James, for some peculiar reason, didn't accept that idea. He then highlights this as Gibson's error. Gibson is then imprisoned in Edinburgh Castle at his own expense. So James here is determining that actually, no, this was flawed reasoning, this is therefore a criminal speech, you are therefore to be imprisoned. And as I mentioned earlier, David Black also appeared in front of the Privy Council. His first appearance, August 1595, ends with informal conference where everybody's apparently very happy. Black is back in November 1596, this time for preaching allegations including that James VI was lying, the Privy Council was full of atheists, he insults Elizabeth I in various interesting ways, and encouraging armed disobedience to the king. Black then says that the Privy Council has no jurisdiction over any of this because this is all in a sermon, it's therefore doctrine, it's a matter for the Kirk. James personally, according to the sources, rejects that jurisdictional point. He says this case is altogether civil and not spiritual, and therefore it's for the Privy Council. He's there, he's resolving the jurisdictional question, in a way we would have expected, but he's still resolving it. Once Black is then found guilty of seditious sermons, the Privy Council decide not to sentence Black. They instead authorise James, or say to James that he should be the person who determines the sentence alone. There is no record of the sentence in the Privy Council records, but we know from other sources that James prohibited Black from returning to his post in the Kirk at St Andrews. And I think, thanks to the efforts of John and the other organisers, we agree that's a very serious punishment. There are more troublesome ministers in Scotland, as anybody who deals with Scottish Reformation history would know. In summer 1617, James comes back to Scotland for the first time after becoming King of England, and he sits judicially in the Scottish High Commission, which is a Jacobean innovation. He does it here in St Andrews, and he tries ministers who objected to the introduction of certain ceremonies into the Kirk. 2 of those ministers end up imprisoned. One of them ends up exiled. James is identified as presiding over the trials. What we don't have is an account of what he was saying in the trials, but he was apparently presiding. Now, these ministers are not seditious. They're not actively encouraging disobedience to the king, suggesting the king could be deposed or anything like that. But from James's perspective, this is still very much a political case. The ministers disagreed with James's claimed authority to regulate matters indifferent to salvation, ad iafra in Reformation theology. From James's perspective, they were therefore refusing to obey legitimate and lawful instructions, and therefore merited punishment, which they received. Beyond meddlesome priests, technically not quite priests, in Scotland, James acts as a judge in one of the cases associated with the North Berwick witch trials. They're a set of witchcraft cases from the early 1590s, printed reports of which make their way to London and inform some of the content of the witchcraft scenes in Macbeth, which is a play that then James learns about later. The particular case in which James becomes involved actually isn't directly a witchcraft case. It's a case connected to the prosecution of a woman called Barbara Napier. And she, like all the other accused, had been charged with seeking to cause the death of James by witchcraft, raising storms while he was travelling by sea and melting his effigy in wax. And this is all alleged to be at the suit of the Earl of Bothwell, who is the son of the illegitimate son of James V. So potentially, were James to die childless, a claimant to the Scottish throne. So there's a very political angle to these witchcraft cases. In fact, they're prosecuted as treason rather than as witchcraft. And on top of these allegations of trying to kill James, various other sorceries, witchcrafts, and consulting with witches are alleged for all of the defendants. Unlike the other defendants in the witch trials, Napier is convicted of consulting with witches, but acquitted of the charges of trying to have the king killed. And as the English agent in Scotland noted, writing back to London, this is not fallen out as was looked for. And what followed was unusual. In June 1591, the assize, the jury for those of us who are English, were prosecuted for error under a legal but very little used procedure. James then arrived in court to sit in judgment in the trial of the jury in the case. At which point the defendants submit to the king's will, and then James declares his will, effectively the sentence, which is described as being in judgment. So he admits, I am sitting as a judge here to dispense with this case. Now they have admitted it and set themselves before me. And in fact, what James decided was that the assize members could leave without any further penalty. Perhaps sitting through one of his speeches was enough. We then move to England. James seems to act as a judge, or think he's acting as a judge, in the attempts to resolve questions of jurisdiction between the church courts and the common law courts in 1608, 1609. The manuscript tradition is very messy for these particular meetings, but there are several sources which refer to James claiming a judicial authority in these proceedings, and Cook then saying the king doesn't have judicial authority, which presumably means he's reacting to something that was said rather than just deciding to throw this in James's face. Not that that would necessarily be inaccurate for Cook on occasion. After Cook denies James's judicial authority in these questions about common law church court jurisdiction, James's remaining judicial activity is all in the Court of Star Chamber, despite, in fact, Cook's explicit denial of James's power to sit as a judge in that court. James begins to sit in 1616, his final case is in 1619, so it's a fairly short period in England. There are 3 occasions on which he sits as a judge. The first of these is a topic to which Neil Jones made reference in his paper yesterday, which is the jurisdictional tug-of-war conflict between the common law courts and the Court of Chancery in the middle years of the second decade of the 17th century. And historians have talked about this dispute a lot, but what's usually passed over quite quickly is actually James's formal attempt to end the dispute. That's it. James does it, the end, but there's more there that we should be talking about. This is the first occasion on which James appears in the Star Chamber in his reign. It's a big state occasion. He delivers a lengthy speech, which is then in fact printed as the final work in his printed collected works, which come out the next year or so in English and then are circulated in continental Europe as well. So for James, he sees this as a major occasion. And it's easy to see this in a sense as judicial activity. He's trying to do again what he did with the church courts. He's trying to resolve a jurisdictional problem between courts in England. What's slightly awkward, particularly for me, is that in the speech, James says, "I am not acting judicially, but declaratorily." So whether he's acting as a judge seems somewhat unlikely. However, if you read the speech, James at the very least exploits an ambiguity about his situation when giving this particular speech. A considerable portion of the speech is about whether kings can judge generally, suggesting he thinks this is an important issue for the speech he's giving. He refers to himself as sitting in the seat of judgment, which suggests he sounds like a judge. And he tells all the other judges who are in Star Chamber at this point, "You are judges with me when you are here." So I'm judging and you are judging. We are all judges together. James seems to be presenting himself as a judge in this particular instance, even if he says that what he's doing is not actually giving judgment. So I've included this speech in James sitting as a judge because I think it makes sense to do so. But it's possibly on the borderline. A non-borderline case, February 1617. There is the prosecution of two young men from the Inns of Court called Christmas and Bellingham, who had arranged a duel and had attempted to leave the country to have the duel. They were stopped at Dover, and then they are prosecuted in the Star Chamber. They both confess. So James's only role in this case is to give sentence. James's speech is briefly reported in the state papers, and there are short reports in letters which form the basis of those state papers' references. There is, in fact, a much fuller version of James's speech, which people have unfortunately overlooked, which seems to have been taken down and possibly circulated, given the collection it's in, by a witness. And that version of the speech runs to 5,500 words. So again, a pretty lengthy exposition by James. Now, that report of the speech correlates very neatly with the versions we have in the state papers, but much expanded, and it gives me the opportunity later on to exploit it to give a fuller consideration of James's own views. The final case in which James judges is the one for which I need a PowerPoint slide. You can look at James being dapper as much as you want, but the real reason we need PowerPoint is this. We have the case in Star Chamber of Earl of Exeter and Lake. We could also have the case of Lake and Earl of Exeter because they have cross suits. This is an unusual case in England. It's the most difficult for James in some respects because in this case, James is not just resolving points of law or giving sentence. In this particular case, no one is willing to admit anything. So for the first time in England, James actually has to determine criminal liability. Who did what? Are they guilty? What then should be the sentence? And this particular case concerns two important families, unhappy in their very particular and particularly peculiar way. On one side, we have the Lake family, up-and-comers at this point. The head of the family is Sir Thomas Lake. He is one of the King's secretaries and a Privy Councillor. On the other side, we have the Earl of Exeter, a descendant of William Cecil, Elizabeth's Secretary of State, and his family. Now, Thomas, Earl of Exeter, by this point, is in his late 60s. He's more or less retired to the country. He has a second wife, Frances, who is about 30 years younger than him. Sir Thomas Lake's daughter, Anne, marries the Earl of Exeter's grandson, Lord Roos, so she becomes Anne, Lady Roos. The marriage was not happy, and it became unhappy very quickly. The couple are soon living apart, and as a consequence, Lady Roos wishes to receive property for her own maintenance, which is not under the control of her husband, and her family back her up in this. She's particularly keen, for some reason, on receiving the manor of Walthamstow. I don't know why. Desirability of Walthamstow seems inexplicable to me, but there we go. The difficulty here is that the Earl of Exeter has some residual rights in the manor, and he refuses to relinquish them. And the gossip is that this is at the behest of his younger wife, Frances. The case then escalates from there, and I'm going to quote from an excellent summary because it's easier. Early in the affair, it was rumoured that Lord Roos had been coerced into surrendering property to the Lakes under threat of nullity proceedings that would expose his sexual impotence. Later, the Lakes alleged that the youthful Countess of Exeter had had an incestuous relationship with her step-grandson, who is presumably not entirely impotent. The case gets worse from there, impressively. There are then allegations that the Countess of Exeter is plotting to have Anne, Lady Roos, murdered by poison, and possibly also Mary Lake, Thomas Lake's wife, murdered by poisoning. Both sides sue the other initially for defamation in the Star Chamber. Gossip about the case is everywhere in the second half of the second decade of the 17th century and widens the range of allegations and things that are apparently going on. By the time sentence in the case is to be carried out, John Chamberlain, a well-known letter writer, wrote that the behaviour of Lady Roos, so Anne, was by report was so filthy as is not to be named. But if you're a gossip-mongering newsletter writer, what you do is go on and name it anyway. And that incest which they would have imposed upon others returns on their own heads betwixt her and her brother Sir Arthur. And quite nicely, William Lord Roos has died in 1618, so he's not around for any of this. He fled to the continent because he was so embarrassed, apparently. Ultimately, Anne remarries, and her headstone reports was dying as a loving wife and a penitent Christian. Ultimately, the case had 12 legal issues, which were delegated to the two Chief Justices, which they resolved in, we think, December 1618. Then after the 12 legal issues had been resolved, the case takes 5 days of hearing in the Star Chamber, during which James sits in a chair of state elevated above the table about which his lords sat. So he is physically present for 5 days in the Star Chamber, in the sense of by name the Star Chamber. There's a letter from the Archbishop of Canterbury who says that this case is considered to be so significant, so likely to have such a large audience, that it's going to be heard at the great banqueting house, at the banqueting hall in Whitehall, rather than in the usual Star Chamber, which wouldn't have been able to accommodate it. Ultimately, the Lakes are found to have defamed members of the Exeter family. They're also found, quite importantly, to have suborned false testimony, crucially by Thomas Lake abusing his position as a Privy Councillor. So this becomes more than a simple defamation case. So these are the cases. We don't need to think anymore. There we are. What about James's views of himself and other kings as a judge? We'll come back to the cases when we start doing the linking together of theory and practice. James's idea of kingship, at least in his idealised form, is biblical. You get frequent references to David and to Solomon, and it hardly requires the wisdom of Solomon to find examples of biblical kings judging. We see this in the True Law of Free Monarchies. We see this in Basilic and Doran. Both these are texts by James. We also see it in all of his judicial activity. In the Napier Assize, James says, I'm getting confused with what James would think there, God hath made me a king and a judge. His 1616 speech begins with a reference to Psalm 72. Give the king thy judgments, O God. Christmas in Bellingham, James makes a reference to Psalm 101. Mercy and judgment belong to the king. In the Lake family litigation, we only have second-hand reports, but those include the king made a speech in the Court of Star Chamber, comparing himself to Solomon, called to decide between two women. In that case, James also compares the defendants to Adam and to Eve, and as he's the judge, that rather puts him in the position of God. Typical early modern modesty. There is one other possible influence on James, which is the Republic of Jean Baudin. We know that James's 1616 speech definitely makes use of a peculiarly Baudinian metaphor, like quite a few other people in England at the time. Baudin talks about kings as judges in Book 4, chapters 6 and 7 of the Republic. Baudin acknowledges that this is a possibility, although he ultimately advises against doing it, which James clearly disagrees with. And we'll see as we go through that several of James's views about kings as judges seem to echo material you can see in Baudin. But James goes further than this. There's more than just kings are judges or kings can be judges. He has ideas about what type of cases kings should judge in, and crucially what type of cases they shouldn't judge in. No one's really talked about these because they're mainly in the judicial remarks, and most sort of political thought analysis of James has focused on his printed works, which only includes the Star Chamber speech. His judicial remarks show that James accepts there are certain things he either could not or should not do as a judge. From a certain perspective, the most interesting is actually his first judicial speech in the Napier prosecution. James says that upon crimes touching men's lives, as adultery, murder, theft, rebellion, if the prince should sit in person, it might be a note of rigour, and therefore it is forbidden in the civil law. Interestingly, James seems to be accepting a legal limitation on his powers to act as a prince. Even if he believed that in 1591, he doesn't accept it by 1601 because he's sitting in capital cases to get people executed for coining and theft. And he certainly, in England, never presents the idea that the law can prevent him from sitting as a judge. In England, his restrictions are pragmatic. The first of these is just expertise. He acknowledges in his 1616 speech that he decided not to sit as a judge immediately when he came to England. He says, "I resolved with Pythagoras to keep silence 7 years and learn myself the laws of the kingdom." And then in 1616 he says, "Well, I've waited for 14 years, double apprenticeship, I'm ready." And then he gives judgment. This is probably a direct response to Coke, who in 1609 had said James didn't have the expertise to be a judge. So it's another slap in the face for Coke, in a speech which is full of slaps in the face for Coke. Because that idea never comes back in his speeches. It's only in that 1616 speech. Ideas that appear more frequently, though, are particularly the idea of partiality. James admits that he shouldn't judge in a case affecting his own interests, and that he ought not to judge, he says, in 1617, in cases concerning jurisdiction. And there he says, "I might be thought to carry some partial inclination." And I think that "I might be thought" is the key part there. This isn't about whether he is partial or not. What matters is if people think he is partial. He doesn't want people to think he's a biased judge. Now, that concern with the appearance of partiality can be seen in 1591 as well. So a quarter of a century earlier, James is expressing the same idea. He says there, "I would not that any of you should think that I prosecuted this in respect of mine own particular." Again, it's this, I don't want the people who are present in court to think that I'm biased. Whether I am or not is not the issue. The key question is what I look like. James never says why this appearance of partiality would be bad. Possibility of influence here from Baudin. According to Baudin, when a prince is ending disputes, the prince above all things must beware that he show not himself more affected unto the one part than to the other, which hath been the cause of the ruin and overthrow of many princes and estates. So there's a cautionary tale in Baudin, don't appear biased. And again, for Baudin, this is about appearance, it's not about substance. The other restriction that comes up in several occasions for James is that the case has to merit his attention. Not every case does, he says in 1616. "A mean cause was not worthy of me." That appears again in Christmas and Bellingham. "I shouldn't sit in a case of too private a nature, nor in a case of people of so base a rank." It's got to be significant people or a significant case for it to merit his particular role. And again, Baudin has something almost identical. "A prince should only be involved in causes such as may seem worthy the prince's hearing and judgment." Baudin gives you absolutely no guidance about what those might be. And similarly, James's restrictions here don't really positively identify the cases in which he should sit as a judge. Some of these we can go, well, they're politically expedient. He's doing this because it's helpful for him. David Black's prosecution, there's a quote from historians, "wrestling match between the Kirk and the King." James is intervening to resolve it. Barbara Napier, the prosecution of the jury is basically to get the rest of the prosecutions back on track. You convict the jury for having got the wrong decision, the narrative is back that no, really, everybody is trying to kill the king and we're trying to do something about it. Christmas and Bellingham, the duelling case, is part of a much wider campaign by the king and other members of the Privy Council and the British English government generally against duelling. The case about Thomas Lake risks reputational damage to James via the Jacobean court in the context of the Spanish match, where James is trying to arrange a Spanish and crucially Catholic wife for Prince Charles. But those political explanations aren't sufficient, because there are lots of politically important cases where James doesn't judge. He usually doesn't need to. The judges do the job for him perfectly well. He resolves scandal at court through the English judges in the Overbury scandal. Most of the witch trials work perfectly well without James being present in Scotland. Christmas and Bellingham, James even says, well, I haven't sat in 2 other duelling cases where I could, but I have sat in this one. But in the speeches we get a bit more. We do get some ideas about why he might have chosen these cases. And coming back to our plenary a couple of days ago, one recurring principle that James refers to is performing the office of a king, linking this to scriptural examples of biblical kings. So in the Napier prosecution, James attributes the acquittal of Napier to partiality on the part of the assize, which he says is a particular problem in Scotland. All men set themselves more for friends than for justice and obedience to the law. And let a man commit the most filthy crimes that he can be, yet his friends take his part, and first keep him from apprehension, and after by feud or favour, by false assize, or some way or other, they find means of his escape from punishment. And James then says, well, I've come to judge the assize, since the common assizes do not as well condemn the guilty as clear the innocent, which are alike abominable before God, as Solomon teaches. I was moved at this time to charge this assize of error, and this I do of conscience of that office which God hath laid upon me. This is his duty. Making sure here that the justice system performs as it should is something James thinks he is required to do. And that idea of making sure the justice system works, that may explain some of our jurisdictional cases where James gets involved, because there is a serious concern on the part of the church courts in particular that the prohibitions from the common law courts are stopping people being handled in the church courts where they have acted contrary to the laws of the church. Similarly, in relation to the Chancery, the Cook and Ellesmere's dispute is stopping the system potentially working properly. And the idea of royal office comes up again. Christmas and Bellingham about duelling. According to James, the case concerns the peace of the kingdom, which is the proper office of a king. Once again, it's his office that's coming forward. Another aspect of this, in Christmas and Bellingham again, James notes that there's a need here to supply the law, to supplement what already exists or to put something new into place, because no laws have been heretofore made against duels because till of late they were never practised. And here, that's also about the legal system not working as it should. There aren't any laws in place, so the regular legal system can't handle it. I'm coming in, I can resolve this. And this particular failure of the English legal system is highlighted in James's speech by the very lengthy passage where he goes through biblical examples about how killing in general and duels in particular are prohibited in the Bible. They're also prohibited in French law, which he noticed, and Spanish law and things like that, but the real focus is on the biblical stuff. And that securing of peace through royal justice as part of a royal duty is also, if you go all the way back to James's True Law of Free Monarchies, we can see it there. He discusses the role of a king as a judge, and straight after that, we have a reference to the obligation of a king, referring there to David, to procure the peace of the people, and he makes an allusion to Psalm 72, so we bring it right back to the scriptural side of things. Thomas Lake looks weird. Defamation between a couple of important people doesn't seem to fall into this kind of category, at least in England. There's no obvious royal duty invoked about people being insulting to one another. But James's remarks in his written material on the idea of kingship suggest there are reasons why he thinks this is important. The first is that the people involved here are members of James's court. And as a matter of presentation, allegations of reprehensible behaviour at court undermine James's prestige, just as they had done with the homicide case about the Overburys a few years earlier. But more generally, James consistently says that maintaining court morality is one of the duties of a good king. And the Basilican Doron, that handbook for his son, make your court to be a pattern of godliness and all honest virtues. Be a daily watchman over your servants, that they obey your laws precisely. For how can your laws be kept in the country if they be broken at your ear? Punishing the breach thereof in a courtier more severely than in the person of any other of your subjects. And above all, suffer none of them, by abusing their credit with you, to oppress or wrong any of your subjects. So these are things James thinks a king must do. And the Lake case ticks almost all of these boxes. You've got allegations of incest, adultery, and poisoning happening at the royal court. You've got oppression of subjects by a privy councillor. Parts of the allegations against Thomas Lake are that he has abused his office as a privy councillor. He had individuals arrested without cause and then used the opportunity to imprison them and then suborn them into giving false testimony in the case, although a number of them resisted doing so. The king's duty, as James sees it, as that watchman over his courtiers and people close to him, is therefore clearly engaged. He needs to redress the oppression, using the language from the True Law, that Thomas Lake has engaged in. There's probably also an underlying trigger in this case of two aspects of the case, which are gender and religion. The dispute between the Earl of Exeter and Thomas Lake formally is between two men. It's usually described by contemporaries as between two women. It's called the famous women's cause by a number of people. And for the Lake family, the matter gets more serious. When James gives his speech at the end of the case, he's described as, James spoke long and well, comparing Lake to Adam, Lady Lake to Eve, and Lady Ruse, the daughter, to the serpent. We've got the pater familias has been swayed to sin by his wife, who has herself been tempted by her daughter. This is about as disordered a Jacobean family as you could get. And if you were to read standard Jacobean thought about the family and the household, this kind of disorder will lead to disorder in government, which is exactly what has happened. Thomas Lake has abused his position. Lake apparently not only arrested these innocent people to suborn them to giving false testimony, even worse, he'd allowed his wife to become involved in questioning and pressuring the prisoners. One report of the case, and this is a report of the proceedings in front of the Chief Justices, describes the finding as that when Lake had examined Williams on matter of state, he gave him to his wife, the other defendant, to be examined again by her. And James alludes to this aspect of the case in his speeches at the end. He bade all secretaries beware of trusting their wives with secrets of state. Women should not be involved in this kind of thing. And linked to this gendered aspect of the case is a concern with religion. There's rumours of religious deviancy all the way through the case. Lord Roos, the grandson of the Earl of Exeter, is at one point suspected of being a Catholic, particularly because he then dies overseas, possibly with a Jesuit taking final confession. But over time, it's also suspected that the Lakes are Catholics, or at least that the ladies in the Lake family are Catholics. And in his speech at the end, James charged the judges to beware of papists, especially of women, who are the nourishers of papistry. And we've got an inference here that there's a fairly significant threat that's posed if these women can control the men in their family, as happened in the Lake family, especially if that man is a servant of the king. This is a route for the Privy Council to become Catholic and do very naughty things. So although the Lake family litigation looks somewhat ridiculous at first sight, it touches on a number of issues that James thinks is very important in relation to his royal duty. Oppression of subjects, behaviour of courtiers, maintaining Protestantism, and godliness at the court. This is a politically significant case that touches on things that he thinks are important for him to do. There's another recurring thread in these cases, which is the royal judgment as an aspect of governing the country. Although James was very overtly judging in particular cases, he sees his judgments as having wider consequences. And this he sees as an important aspect of his judicial activity. In fact, as the Archbishop of Canterbury writes in a letter about the Lake case, the matter is held so exemplary that the king himself intends to be present. It's because it's enabling him to make an example that he wants to judge this case. And for some cases, for James, personal participation may have been necessary for the case to be an effective example. The Napier Assize, going back to 1591 in Scotland, James says that I see the pride of these witches and their friends, which cannot be prevented but by mine own presence. James is the only person who can deal with this. Other people can't stop this. In Christmas and Bellingham, James knows that previous cases have failed as examples, suggesting that he's stepping up because exemplary judicial activity has not worked so far. And in the Napier Assize, James takes this further. James explicitly says, I move to charge this assize of error that it may be an example. He wants this to explain to other people that they should judge properly if they're a jury. And he not only takes the opportunity to explain that juries should apparently give correct verdicts, shocking as that might have been in Scotland at the time, but he goes on to say, he also says that for the substance of the offence which Barbara Napier has acquitted, the witchcraft allegations, for them who think these witchcrafts to be but fantasies, I remit them to be catechised and instructed in these most evident points, and then he seeks to prove, and thinks he does prove, the existence of witchcraft and its use in these cases. He's teaching the wider community about this. And this idea of royal judgment as education, a means of educating one's subjects, is something that's acknowledged in that 1616 speech in the Star Chamber. James says, of course, he needs to learn the laws of England, followed up with, before I would take upon me to teach them unto others. He thinks that he needs to learn the laws to become a judge, and when he becomes a judge, he teaches the law to other people. We get a very complete statement of this in the Christmas and Bellingham long speech. What can belong more properly to a king than considering that all kingdoms are governed chiefly by example, to make such an example, as may hereafter curb the insolent minds of these jewellers, and by solemn decree provide that the country may be reformed, and shedding of blood hereafter stayed. Again, for which purpose I have such an account to make before God. So again, I've got to do this, because otherwise I get in trouble later, and an example is the way to do it. And that presumably explains, this educational purpose explains why James makes such a long speech, demonstrating the unlawfulness of duelling in Scripture and in the law of nations. Education through justice as a vital, albeit very rarely deployed, tool of royal government. Perhaps particularly important in the duelling context where previous interventions by the Privy Council have failed to curb the behaviour. May also explain some of the intervention in the Lake case. This is the second prosecution in a few years of courtiers for disgraceful behaviour at court. The first is the Overbury scandal, which is much more notorious and comes back in political discourse all the way through the 1620s, 1630s and into the run-up to the Civil War. The Lake case, because no one actually seems to die, sort of fades away from memory. But for James, I think what he thinks is we've had the Overbury prosecution in front of the normal judges, and they're still misbehaving at court. And so he comes back to try and stop this. And this idea of exemplarity, of trying to change people's behaviour, is visible in Basilic and Doran, 1598 completion. James stresses there not so much the teaching part of the judgment, but the idea that when James imposes sentence, it's there to shape behaviour. If you should show your clemency at the first, the offences would soon come to such heaps, and the contempt of you grow so great, that when you would fall to punish, the number of them to be punished would exceed the innocent. So he's encouraging you to give harsh sentences to a few to discourage criminal behaviour amongst the many. Christmas and Bellingham, again we get this. Nothing is more hurtful than cruel mercy, so nothing is better than merciful justice. Cruel mercy is where the pardon of one procured the faults of many. Merciful justice is when the punishment of a few scares millions. For that is God's ordinance in the seat of justice upon earth, that the punishment of a few might add fear to many. So James, by imposing a harsh sentence, he sets fines of £1,000 in that case for each of the parties, which they never pay, but they're imposed originally. He's making an example of a few offenders for the greater good. And in the Star Chamber is a great place for this. It's a court that people attend. In fact, they pay for the seats about as much as you pay for a seat in the theatre. And the people who attend the Star Chamber then circulate news about it in letters. So news of what happens in Star Chamber spreads quite widely. James therefore sees his royal judgment as royal government. He's trying to shape behaviour in his realms, in line with his duties as a king, through activity that will be publicised and which can disseminate ideas and norms of appropriate behaviour to the wider community in his kingdoms. And in that sense, James's judicial activities deserve to be considered in relation to James's ideas and practice of kingship and of government as a whole. I'm skipping over a bit because we're cutting down our timetable. To end with the comparative legal history, we've got one very clear distinction between James as a judge, regular involvement in the judicial process and the legal process in Scotland, nothing like that in England. There's a clear distinction there in the regular dispensation of justice, and that's probably a combination of institutional and cultural differences between England and Scotland. But in other respects, the pattern between England and Scotland looks quite similar. I've been able to freely move between a 1591 case in Scotland and a 1617 case in England, between James's writings in the Scottish context and the English cases. The more pronounced differences, in fact, are between very early James' judicial activity, where he is fairly lenient. Think about the letting the assize go in 1591. He harangues them, but that's all they get. And letting David Black go in 1595. From about 1596 onwards, he's much more concerned about punishing in an exemplary fashion. In Basilic and Doran, completed in 1598, James admits that his view of mercy had changed by that point due to quote, his over-dear-bought experience. There's a particular habit of James in the 1590s of letting people go with a slap on the wrist and then they commit treason again and rebel against him, which probably explains that. That experience, though, seems to shape James's ideas, which are the ideas he brings with him from Scotland into England and which he applies fairly consistently in both of those two kingdoms. The comparative exercise here therefore lets us reach a conclusion which would have delighted James himself in his ideas and practice of royal judgment. We seem to have an example of genuinely British legal history. Thank you.